So in relation to Headley Byrne, also be familiar with the Capero decision as well, and also tied in with your solicitor's negligence as well in terms of advice given causing financial loss and so forth. Occupier's liability is the next area then. Occupiers hasn't come up in some time on the examination paper, and to me it's a vitally important area in the work of a solicitor, I would think, particularly given the geographic nature of Ireland in terms of this green isle of ours where, you know, we have a lot of hill walking, mountain climbing, and people undertaking outdoor activities and so forth. Again, this is important here is your knowledge of the statute. This is governed by the Occupiers Liability Act 1995. That supersedes and replaces all the common law in this particular area. So knowledge of the 95 Act is the be-all and end-all within this chapter. You can break this chapter down into 1, knowing what the definitions are in the Act. The definition of a premises includes dressing rooms, football pitches, trains, cars, etc., whatever. They've been defined as premises. To define danger, you'll recognise an occupier's liability question on the paper because the injury is caused not by the behaviour of somebody on property, but because of the property itself or the state of the property itself. So there is a case of Hackett versus Calla Associates whereby a bouncer attacked a customer of the nightclub. The customer sued, and amongst other things, sued in occupier's liability. And the judge pointed on that case, well, look, you can sue in negligence because the bouncer should not have attacked you in this manner, but you can't sue in occupier's liability. Your injuries didn't occur because of the state of the premises. They occurred because of somebody's behaviour on those premises. So if that was a different situation whereby you slipped in a nightclub on a broken glass and cut your arm, now that's an injury that's caused due to the state of the premises, and that's the type of claim that would fall under occupier's liability. So be able to recognise occupier's liability by looking at the question. It involves some property or premises. Again, remember, it can be a train, it can be your football field, it can be a block of flats, it can be a house, whatever the case may be, a public park. And then if the question involves injury caused by the state of the premises, then you're down the road of occupier's liability. The next point in relation to occupier's liability then are the categories of entrant. 3 categories, know the definitions: visitor, recreational user, trespasser. So the question will have somebody doing some activity and you'll have to categorise them, put them into a particular box, because the duty that is owed to that person on the property flows from his category as an entrant. A visitor is owed a duty of reasonable care akin to negligence. Recreational user and a trespasser is owed a lower standard of care from the occupier, and that is not to intentionally harm him or act with reckless disregard for his safety. Focus in on this idea of reckless disregard. The Supreme Court has struggled with this, so don't worry if you struggle with it when you're doing your revision. Reckless disregard has not been defined in the Act, but it does give a list of guidelines. Now, reckless disregard basically is, while you didn't deliberately intend to injure the person, put it this way, what did you think was going to happen when you did what you did? So if there was young kids playing football in a public park beside your house all the time, and the ball was constantly going over your back garden, and the kids were climbing over the wall and getting their football and trouncing all over your flowers. So one day you decide, well, that's it, I'm breaking glass, I'm putting it on top of the wall, so that when they come over, they'll be injured. So the kids playing football the next day, little fella jumps over the wall and he's cut, okay? Now in that situation, you may not have intended to injure them. In other words, you didn't break the glass, go out to the kid and stab him, but what did you think was going to happen given the circumstances? That's acting with reckless disregard, okay? So be familiar with that and focus in on the case there involving, the name has gone from me, escapes me right now, Weir Rogers versus San Franciscan Trust, where the lady sat on the edge of the cliff to look at the sunset in Donegal in the bay, and she slipped as she got up to leave. And she brought an action. The High Court said, yes, she was a recreational user, and said that the owner of the property or the occupier of the property had acted with reckless disregard. Supreme Court rejected that, saying, well, that's ridiculous. Ireland is an island. It's covered in cliffs. What do you expect if you sit near a cliff face? It could go from under your feet. To do otherwise, or to decide otherwise, would be demanding that landowners all across the coast put up signs saying, be careful, cliff, you might fall. So the Supreme Court rejected that. But they basically defined reckless disregard as something exceptionally unusual. So look for that in the problem question. It's something exceptionally unusual. One final point on that as well, be familiar with the other issues like disclaimers and warnings, and also the situation in relation to, it's completely gone from me now, I'll get back to it later in relation to occupier's liability. Okay, so occupier's liability, I would focus heavily on that. It hasn't arisen in some time and, it could be due a run. The next area then is employer's liability and vicarious liability. Treat both of them the same, okay? Employer's liability did come up in the last paper as a subset of a question mixed with vicarious liability. But in relation to employer's liability, I would focus in on the employer's direct liability towards his employees. So in other words, safe place of work, safe system of work, safe equipment, etc. Possibly, and this is just my own personal opinion, possibly maybe the question might focus in on the employer's liability for stress-related illness caused by the workplace. So in other words, what is the liability on an employer in relation to stress-related or psychiatric illnesses that an employee suffers because of his work? Okay, and there's three key cases for you to be familiar with on this point. There is the Hatton versus Sutherland County Council case, English Court of Appeal decision 2002, I think it is. There is the Barber versus Somerset County Council decision, English House of Lords decision 2004, which is appealed from the Hatton decision. And then finally, we have our own High Court decision in 2004, McGrath versus Trintech Technologies. And basically what you're saying that those cases are saying is that where an employer could have reasonably foreseen the psychiatric illness or the onset of the psychiatric illness, he will be liable for it. So if an employee is coming in every day and there doesn't seem to be anything wrong with him, he seems to be perfectly fine, he's coping with all the pressure, the employer asks, is he okay, does he need time off, oh I'm fine, everything's great, and so on, and he flips out someday and then brings an action against his employer, well that case is unlikely to succeed. If on the other hand, this employee's been put under pressure, extra workload has been placed on him, he's been asked, he's asked for more help, he hasn't received it, suddenly he starts coming in, he isn't taking showers, he's coming in his pajamas, he hasn't shaved in 3 days, and then suddenly he has a breakdown. Well, in that situation, the questions will be asked of the employer, well, surely this was reasonably foreseeable. You placed greater pressure on him, you asked him to do more, his attitude changed, his appearance changed, etc., and yet you did nothing. So what you're looking at there is looking at the standard of care, and when it becomes foreseeable that the person is suffering from a stress-related illness, then and only then is an employer obliged to act. Again, that's just a personal opinion. Those cases have come up recently. Maybe it's due or run out. Vicarious liability is attached to this, and you're looking for actions of the employees that injure third parties. Don't confuse the two. Employer's liability deals with the liability of an employer towards his employees. Vicarious liability deals with the liability of an employer for the actions of his employees towards a third party. Okay, so in a vicarious liability question, you're looking for somebody injured who is not an employee, or not necessarily so, or who is even injured by an employee. Okay, so you're looking for that connection. Be familiar with the independent contractor versus employee test, which is basically a control test. Phelan versus Kyle-Cioranta is your key case on that. And the second issue then is the question of whether the employee's actions were within the scope or within the course of his employment. So there's some debate about those two tests. Are they different? Scope seems to be saying if the employee was acting within his authority, whether it be implied, express, or delegated, well then he will be liable for any injuries, the employer will be liable for any injuries caused by the employee. However, if he acts outside his authority, so in other words, the employer gives a ban and says don't do that, and he goes ahead and does it, the scope test is limiting in that it says, you're not liable for that. So people criticize it as being too limiting. The course of employment test then basically says if he's doing anything in relation to his work or anything reasonably incidental to his work, well then the employer will be liable for the actions of the employee, a much more liberal test. And maybe pay attention to a number of the cases involving sexual abuse cases against the clergy and schools, etc., and as to whether the actions of a teacher, for example, will make the state liable as the teacher's employer. And the Delahunty case recently has decided that, yes, potential liability could exist in those circumstances.